Everyone who leaves the military service of the United States gets a discharge. We refer to it, it's called a DD-214. Anyone that's served in the military knows that their DD-214 is one of the most important papers that you get when you leave the military. There's types of discharges that you can get when you leave the military. The highest discharge you can get is an honorable discharge. Underneath an honorable discharge is a general discharge under honorable conditions. Underneath that is an other than honorable discharge. Below that is a bad conduct discharge, and down the bottom is the dishonorable discharge. You can only get a bad conduct discharge or a dishonorable discharge from a court-martial, which is akin to a criminal trial in the civilian world. So the types of discharges issued by the military are what we just went over. In order to qualify for eligibility for VA benefits, you have to have a discharge that's characterized as conditions other than dishonorable. And that's a little bit confusing because a lot of people would think, well, as long as I don't have a dishonorable discharge, I'm entitled to VA benefits. Well, the VA has their own little set of rules, and basically they will consider anything that is not a general discharge or an honorable discharge potentially a dishonorable discharge. So if a service member comes to you or a veteran comes to you and says, hey, I served in Vietnam, when I got back I got an other than honorable discharge for whatever reason, most of the time we see drug use or other issues, it does not mean that they're going to be entitled to VA benefits. What the VA will do is the VA will do its own inquiry to see, is the characterization as a whole, should we characterize it as honorable or should we characterize it as dishonorable? Now, the majority of the time, if you can prove that the service member served in a combat zone, you might be able to prove that as a whole, their service should be characterized as honorable. So a lot of times we can get service members that have other than honorable discharges, sometimes even bad conduct discharges, to be entitled to certain VA benefits. Statutory bar to benefits under certain circumstances. If you're a deserter, if you spy on the United States, those are bars, statutory bars, which basically mean that you cannot get VA benefits. Establishing eligibility for benefits. VA Service Department records. What normally happens is the service member, when they leave the military, is anyone in here a veteran? Okay. So when you left the military, likely what happened is you indicated on your DD-214 when you out-processed out of the military where your home of record was going to be. And what used to happen was your military treatment file would be sent to the VA. The paper file would be sent to the VA. And quite honestly, it hasn't really changed that much in 50 years. The military still basically sends a paper copy of your records, and a lot of times what happens with the VA is the VA loses those records. So we're going to talk about ways that we can recreate records when there's no military records available. The VA and the military is now, if anyone gets treatment at the VA, they would know that the VA is basically all paperless. If you go for your treatment at the VA now, everything is done electronically and they have an electronic record. There's no more paper records at the VA. However, the military, for the most part, is not as up to speed as the VA, so the military branches are still using paper records for the most part. Some of them are now using electronic records. But the two systems, of course, don't talk to each other right now. So you have paper records that a lot of times will go to the VA, and then you have the VA creating electronic records, and this creates confusion, to say the least. Right now, there are over 800,000 veterans' claims pending adjudication. The average time to adjudicate a veteran's claim from the time it's filed to the time it's adjudicated is about 18 months to get the first level of adjudication. So, as you can see, many veterans are very frustrated, and a lot of them will be very frustrated when they come to see all of you. There is a bar that goes all the way back to the Civil War that says because all lawyers are unscrupulous, we cannot represent veterans at the initial stage of filing a VA claim. And this goes back to the 1860s. However, we can represent a service member for a fee or a veteran for a fee after there's one initial denial. So you basically have to wait until the veteran has gotten a denial of a benefit, and then you can file on their behalf for a fee. Before that, you're not allowed to charge a fee to represent a veteran. So what will happen is basically claimants, they submit their documents, the VA then adjudicates the issue of the characterization of service. So if someone has an other than honorable discharge or bad conduct discharge, basically the VA will go through the adjudicative process to determine are they going to be entitled to benefits. A lot of times what will happen is the VA will come back and say, okay, we're going to deny anything that is not service-connected. And what do we mean by service-connected? Service-connected means anything that basically is not connected to your time in service. So if you have a veteran that comes back and he lost part of his arm in combat, comes back and gets an other than honorable discharge for some other reason, the VA will treat him for anything related to the service-connected injury, but will not treat him for anything that is not service-connected. Exceptions to eligibility for benefits. There is an insanity exception, which really needs to be updated because it really shouldn't be called the insanity exception. If you can prove if somebody was suffering from a severe mental health issue at the time and that related to their discharge and that's why they got an OTH, you might be able to get an exception and be treated at the VA. Forfeiture, there's certain provisions that if you are convicted of a crime, your VA pay will stop, your disability pay will stop. And willful misconduct is also another reason where your VA pay will stop and your eligibility for benefits will stop. Benefits for service-connected disabilities, and let's see. General requirements to receive disability compensation benefits. There's two types of benefits that you can basically get when you file for VA, and I want to talk about each one kind of separately so it doesn't get so confusing. Is you're entitled to, if you file with the VA, one of the things that most veterans will come to you for is they want to get compensation. So compensation basically compensates a veteran for the loss of their earning potential because of a service-connected disability or a disability. It's not what we would say disability payment. It's not like SSI, or it's basically compensating the veteran for their loss of their ability to earn a living. So veterans will come to you and say that they want to file for a disability compensation or a compensation pension. And what will happen is they will be rated once they file the application. You can file online. If you just go to va.gov, the application is right online. They file the application, and then what will happen is there will be a comp and pen physical where they will go in to the VA, and the VA will give them a physical, and they will basically start adjudicating the case along with all records that the veteran has. The VA has an obligation statutorily to assist the veteran in filing the claim. And what will happen is the VA will look through the medical records from the military treatment records, will look through the VA records, and you can also submit additional records as well from your own doctor. And we'll talk about that as we proceed tonight, because I strongly recommend that you do that. Service connected. Service connection is an important concept when filing for VA compensation or VA care. Service connection basically means that whatever injury it is has to be service connected. It has to be connected to your service in the military. It does not mean you have to have received it in combat. Does not even mean it had to have happened on the military base. For instance, I've represented service members who they got into a motorcycle accident while they were driving off base going home. That's service connected because service members are considered to be on active duty 24 hours a day. You could be in the pool at your apartment complex while you're on active duty playing pool volleyball and break your wrist. That is considered service connected. And a lot of veterans do not understand that. And when they come in, they talk to us, or I'm speaking to them, and they say, wow, I never realized I could file for that. Absolutely, they can file for that. There are certain exceptions to that. Someone that has alcohol in their system might not be deemed to be service-connected because now they're at fault. Now, service connection is pretty easy to establish if you're on active duty, if you're in the regular Army, if you're in the Navy, Marines, and on active duty. If you are in the Guard or Reserve, you have to basically prove that it incurred while you were doing your drill, or you were doing your 2 weeks, or you were it somehow was related to your reserve or guard time. Any questions on that? In the line of duty is a concept that applies mostly to National Guard and reservists. Is you have to basically prove that the incident occurred in the line of duty, meaning that if you had a motorcycle accident on the way to drill, could be considered in the line of duty. If you are doing a drill, you come home and you slip and fall on the ice outside, it's not going to be considered in the line of duty. Difference between compensation and pension. Compensation compensates the veteran for loss of earning ability. Pension, there are pensions available to veterans that are making very, very low incomes. I think the income level this year adjusted is probably about $15,000 to $17,000. So if you have a veteran that is making under $15,000 or $17,000 a year, they might be eligible for a pension. However, in order to get a pension, most of the time you have to prove wartime service. However, according to the laws of the United States right now, we have been at war since approximately 1991. So anyone who has served in the United States military since approximately 1991 is considered to have had wartime service, even though they may not have deployed anywhere. They're considered a wartime veteran. Disability ratings. What will happen after you file for your disability is you will get a rating. And that rating will basically say, we find that your condition is service-connected, and we rate you. The VA has a chart on basically every condition imaginable and the severity of every condition, and they have a rating. And the rating can go anywhere from a 0%, and if you're rated at 0%, you're still considered a service-disabled veteran, all the way up to 100%, and in certain instances you can even go over 100%. And there's a schedule for rating disabilities. The percentages don't always add up, and a lot of times lawyers will call me and say, hey, I have a veteran here that has a 20%, a 20%, a 20%, and they only gave him 40%. Well, the VA math doesn't always add up, and they have a chart on basically how they evaluate all the ratings, and each condition is basically subjected to each other condition, and if there's any overlap, sometimes they will reduce a rating. So it gets a little confusing, especially when you have a veteran coming in and saying, hey, this should be 60%, and they're only giving me 40%. Fundamental requirements for obtaining a service-connected disability compensation. You have to have competent evidence of a current disability, medical evidence of in-service occurrence or aggravation of a disease or injury. A lot of times this will happen where you'll have a World War II veteran come in and say, hey, I was in the Battle of the Bulge and I have frostbite, and I've had frostbite for basically my whole life. Okay, well, we say, let me take a look at your military treatment file. And what's going to be in that military treatment file from the Battle of the Bulge? Probably not much, because they were kind of busy fighting a battle. So what can we do if we can't get medical evidence? We can get statements from buddies, and they're called buddy statements, and this is, the VA has to consider a buddy statement if there's not competent medical evidence or there's not contradicting medical evidence. And that can simply be, hey, my name is Sergeant so-and-so. I served with Sergeant Snuffy during the Battle of the Bulge. I was in the foxhole next to him, and I saw that his feet were frozen, or he didn't have boots. And the VA has to consider that evidence. And a lot of times with treatment that is given during combat, we're going to find that initial treatment is given by a medic, by a buddy, and a lot of times there's not strong medical evidence that's going to show that or suggest that. So we can overcome that with statements from buddies. We can overcome that with doctors that have treated the veteran afterwards and say, I've treated Sergeant Snuffy for 30 years and he has complained about frostbite or numbness or tingling in his feet for the past 30 years. Also, there was a big fire in 1970 out in Indianapolis where a lot of veterans' records were burnt. So any records prior to 1970 for the Army, Air Force, and some of the other branches have disappeared because of the fire that was in this warehouse. However, the VA has basically said if there is no records and basically we can prove that the record would have been involved in that fire during that time period, there's a presumption, and you have to give the benefit of the doubt to the veteran. So what you have to prove is you have to prove that there's a link between in-service occurrence of aggravation of a disease or injury and current disability. So you have to actually be able to show that whatever you're complaining of was somehow connected to your service. Many times veterans will come in, and this is especially true of World War II, Korea, and Vietnam veterans. They did not file VA claims when they came home. They will file the claims now. They'll be coming in now and saying, hey, I have this condition, but I never filed. And a lot of times it's hard for us to go back and reconstruct their medical records because their medical records are either missing, they're not there, or these guys and gals did not go to the doctor. They didn't complain about it. PTSD didn't exist really back then. It was considered during World War II and Vietnam and Korea, it was considered battle fatigue. It wasn't considered PTSD. A lot of guys and gals and soldiers during the time period were very ashamed, and they didn't want the stigma of going to a psychiatrist or psychologist. However, we can overcome that sometimes with statements of wives, family members, doctors, buddies, to be able to say that he has been irritable his whole life. He wakes up in the middle of the night with nightmares, and the VA has to consider that evidence. Process of obtaining disability benefits. The VA policy for determining whether a disability is service-connected, and that's Title 38, Section 3.303 of the CFR. And in your handout packet, we gave you a little bit of what we're talking about tonight. There's handouts, there's some case law in there, there's some VA regulations in there, and some of the CFR is in there. So it's a four-step adjudication process at the VA regional office. Most cases in this area here in upstate New York are usually processed out of the Houston Street office down in New York City. However, it can be processed in any of the regional offices. General evidentiary requirements and issues and established service-connected disability. You have to have medical evidence. A lot of times veterans will just come in and just say, hey, I'm a diabetic. And that can work for certain veterans because there's a presumption of service connection for certain veterans. And these are Vietnam veterans. Basically, if they step foot into Vietnam, some parts of Laos, Cambodia, there is a presumption that certain medical conditions were connected to Agent Orange. And those are diabetes, certain heart conditions, certain skin conditions. Automatically, it's service connected. So if you know of any veterans that served in the Vietnam conflict and they have any type of heart issues or they're diabetic, they basically just have to file the form, and automatically the VA presumes presumes that that is service-connected, and they automatically get a disability rating, and they'll get a monthly check for that. The next big push is going to be for the service-connected presumptions that are occurring over in Iraq and Afghanistan. We're seeing more and more guys and gals that are coming back due to either the anthrax vaccination, to the sand. There's been studies that have shown that the sand in Iraq is heavily contaminated with contamination from oil fires, burn pits, and other things. So the next big issue that I think we're likely to see is a presumption for certain service-connected issues for Iraq and Afghanistan. If you don't have one of those presumptions, then we have to prove it through medical evidence. And medical evidence basically has to show that it's more likely than not that the medical condition was caused by their service. Lay evidence is good. We discussed in certain circumstances if there's no medical evidence, you can get evidence from buddies. Buddy statements are very effective, and I've seen them work quite often, especially if there's no medical records. I don't know if anyone saw, but the VA several years back, it was on 60 Minutes, had cartloads and cartloads of records to be adjudicated, and someone at the VA shredded them all while they were in the process of being adjudicated. Therefore, there was a presumption in any of those cases that they had to give the benefit of the doubt to the veteran. So some of you might come across those instances as well where there is no medical evidence or medical evidence has mysteriously disappeared. Whenever we deal with the VA, we send everything either by fax so we can prove that they received it, or certified. Because if you don't send it by certified mail or by fax, the VA will lose it. The agency has an obligation to provide a medical examination. So what will happen is after the veteran comes in and you file the form online for for compensation, what will happen is they'll get a call from the VA or a letter from the VA saying you need to come down to your VA hospital and undergo a comp and pen physical. Basically what the comp and pen physical does is every ailment that the veteran has indicated on their form when they file for benefits, there'll be a doctor at the VA that will evaluate that doctor. That will evaluate the veteran for each one of those injuries or ailments. That VA doctor will write a report and then send his recommendations to the claims adjudicator. I normally tell veterans when you go to those physicals, the first thing you want to do when you leave is you want to go down to the FOIA office, and basically what you want to do is you want to request your medical records. You want to request everything that was done that day, and you want to request anything that the doctor wrote, because it's very important that you can see what the doctor recommended, and did the doctor actually spend the time, and did the doctor actually give you all the medical tests. Because a lot of times we can overturn these cases because these comp and pen doctors, a lot of them are contract doctors and not the best quality of doctors. So we can a lot of times win cases when we can prove that they were not giving an adequate physical. Evidence of an in-service precipitating disease, injury, or event. One of the things that you can basically be disqualified for service connection is if the VA can show that you had this before you went in. Most of the time, everyone that's went into the military, before they went in, they were given a physical. And on that physical, the majority of people that went into the military, they were in the best shape of their life, okay? Now, the majority of people, when they come out of the military, they're usually pretty broke. So what we normally see is most people that are going into military service do not indicate that they have had too many problems, because if they do, they're not going to be accepted. I know when I went into the military, I still remember the recruiter telling me the only answer you check no to is, do you have vision in both eyes? Or yes to is, you have vision in both eyes. Because basically anytime you say yes to any medical condition, it's going to trigger an examination and is going to basically potentially disqualify you from military service. So if you have a pre-existing medical condition, if you go in and on your entry exam you say, yeah, I fell out of a tree when I was 6 years old and broke my arm. When you come out of the military 30 years later, you have arthritis in that arm, you're not going to be able to claim service connection for that. Now, there's exceptions to that. You fall out of the tree when you're 5 years old, and then you serve in World War II, and you serve in the Battle of the Bulge, and now all of a sudden you have arthritis because of maybe frostbite or exposure to cold events. You can probably show that your service has aggravated that condition. And that's a way that we can sometimes get around a pre-existing medical. There's a presumption of sound condition, which basically means they presume that you were in sound condition. Evidence that condition existed prior to service or not aggravated by service. We already talked about that exception. General review of assigning percentage evaluation for rating disabilities. So what will happen is after you get the comp and pen physical, you'll wait and wait and wait and wait, and probably about 18 months later, the veteran will get the decision from the VA that says, we have made a decision in your case. And they will then basically walk through each one of the ailments or disabilities that you're claiming, and they will tell you whether or not service connection has been established, and then they will talk about what rating they're assigning for each one of those conditions. And what will happen is as they rate each one of those conditions, they will talk about the percentage, and they will talk about what you need in order to increase that percentage. After you get that decision, you have 1 year to file a notice of disagreement. So the statute of limitations or the deadline to file an appeal is 1 year. What I normally recommend is what the letter will say is the letter will say, if you disagree with this, notify us in writing within 1 year. And your next step is to go to the BVA, which is the Board of Veterans Appeals. However, I do not recommend that veterans go to the Board of Veterans Appeals right away. There's an intermediary step where you can file for a decision review officer. And what that means is basically you say, I disagree with the findings, and I request that a decision review officer review my case. We just had a case in the last week actually here at the firm where a decision review officer reviewed a case. Unfortunately, it took another 2 years after filing the appeal, where the VA came back and said, you know what, we screwed up. There's something called clear and unmistakable error. And we screwed up, and your 10% really should have been 60 to 100% over the years. So here is your check for $148,000. So it is rare for the VA to come forward and basically say that, yes, there's a clear and unmistakable error, but that's one way of proving that there was a mistake made in a case. And the important thing about that is when you file your claim, and this is why I tell anyone, and anyone that knows anyone in the military, as soon as they get out is when they need to file their claim. Because the date of payment and the date of establishment of that claim goes back to the date that you file. When you get out of the military, you basically have a get out of jail free card for 1 year. So you can file anytime after a year, and it'll still go back to the date that you got out. But if you wait 30 years to file your claim, your date of claim and your date of payment does not go back to whenever your injury took place. It goes back to the date that you filed. So filing is an important date because, as we discussed, in order to establish service connection, in order to establish a claim, it has taken the VA approximately 18 months. So what happens is when they finally make their decision and they finally say, you are entitled to 60%, that goes back to when you filed your claim. So they get the veteran will get a lump sum back to the date that they filed the claim. And the way it works is each month, depending on the rating, the veteran gets a check in the mail. And it ranges from a 40% rating is approximately, with dependents, is about $700 a month to 100%. What is 100% now? $3,000? $3,200? $3,200 for 100% rating. However, with these ratings come a lot of other benefits. You can get dependent education benefits where children of service members can basically go to school for free, where the government will pay their tuition. And there's all sorts of other benefits for the veteran as well. There's Voc Rehab benefits where the veteran can go back to school. And this is in addition to the GI Bill. This is not the GI Bill. This is in addition to that. So some veterans might not qualify for the GI Bill because their service was so many years ago, but they can get Voc Rehab. So what happens is after you get the decision from the VA, and basically the VA says, here's your 10% rating, best of luck to you. Okay, well, we're not going to agree with that. We're going to file a notice of disagreement, and we're going to request a decision review officer. And what will happen is that decision review officer has to be a neutral party that has not been involved in the claim. They have to review why you disagree with it, and it can be as simply as writing, I disagree with the claim, or I disagree with the rating, and I request a decision review officer. That's all the veteran has to write. And then the decision review officer will review the claim, review why the veteran believes it is wrong, and then render another decision. And that decision review officer can either increase the rating or deny it and say, thank you for your appeal, however your appeal is denied. At that point, now you have a year from the date of the decision review officer to appeal to the Board of Veterans' Appeals. And after the Board of Veterans' Appeals, if you disagree with that, you can then go to the Court of Veterans' Appeals. And then from there, if you disagree with that rating, you can go all the way up to the Federal Circuit, Court of Appeals for the Federal Circuit in D.C. As you can imagine, once you start getting into this level of appeals, we're talking years. And it's not uncommon for veterans to come in and they will dump stacks of documents, appeals, remands on your desk and basically say, figure it out because it's been going on for so long. The important thing, though, is when we talk about when to file, we don't want to file a new claim. And a lot of veterans do this. They get so frustrated with it. If the condition has gotten worse, they try and file a new claim. However, what that could end up doing is if you don't appeal the decision and you just file a new claim, your date of payment is going to go back to the date of filing the new claim and not back to the original date. So that's an important tidbit if you are working with veterans, is that you ensure that they're appealing and they're appealing the original claim, and they need to be careful with filing new claims. And some veterans are going to need to file new claims because they're going to come in and they're going to say, hey, I got 20% rating for whatever their condition is, a broken bone, arthritis, limited range of motion, and they're going to say, well, now it's gotten a lot worse. I can't twist, I can't bend, I can't do as much. So yeah, you can file a new claim on that, and the VA can then increase it. You'll have to have another examination by a VA doctor, and the VA can review that and increase it. Now, VA claims can go up and can go down. The VA at any time can basically call a veteran in and say, we want to examine you and see how your condition is doing. So the VA rating can go down. So that's why we sometimes tell veterans to be careful. They come in, and if they have a 60 or 70% disability rating and they want to try and get 80 or 100% disability rating, sometimes we really need to review the documents and make sure that the VA is not going to decrease their rating if their condition has stabilized. There is something called 100% individual unemployability. And what that does for veterans that are approximately 75 to 80% disabled, if we can prove that they're not able to work because of their service-connected disability, we can then file for a 100% rating based on unemployability. And that will increase the rating to the veteran, also give certain benefits to the dependent children and to the spouse. What we're seeing more and more of coming back from Iraq and Afghanistan especially is PTSD. And in this war we're seeing a lot more of that because many of these service members have deployed not once, not twice. A lot of them are now on their 4th, 5th deployments. And the rate of PTSD has skyrocketed based on the fact of multiple deployments. The other thing we're seeing is veterans that are coming back from these wars that wouldn't have survived in other wars because of our body armor, horrendous injuries of losses of both arms, legs, genitalia because of the body armor. So the VA is really seeing an influx of veterans coming back from Iraq and Afghanistan, and the surge continues. So when working with veterans, the first most important thing is if you want to do VA disability, and I encourage all lawyers in this room to take a few cases pro bono or to work with veterans, is you do need to be certified by the VA General Counsel. You can't just take these cases. However, I believe that tonight's CLE will go at least a step of the way of that requirement so that you can take these cases. But you do need to be certified by the VA General Counsel to take these cases. If you do take them for pay, the most important thing to remember is you cannot take them until the veteran has had at least one initial denial. So the veteran can't come into you and say, hey, I need help filing this. If they do, there's the VFW does it, Disabled Americans Veterans do it, the VA actually has liaisons that will do this, and every county in New York has what's called a VA coordinator or a service coordinator that has to help veterans file these claims. Of course, a lot of them are inundated with these veterans that are coming back and the numbers of claims coming in. Yeah?
What's the definition of a denial?
Of a denial?
Yeah, if he gets 20%, is that a denial?
It is well, it's not a denial, but you can appeal it.
Okay.
So if you're claiming, I mean, you don't claim 100%, you basically just claim the injury. The VA comes back and the VA will say, service connection is granted, and then it basically will say what the percentage is. However, what we look at is we want to look at the regulations, and there's a whole slew that will say if the veteran has limited motion of less than such 30%. If the veteran has limited motion of X, it's 40%. So then that's really where the lawyer comes in, and that's where you need to make the argument saying, oh, he misapplied the regulation. And a lot of times they do, because remember, these are a lot of times GS5s that are maybe going through these claims and they're processing 20, 30 claims a day. They're going to make mistakes. And a lot of times they make glaring mistakes. I would say most veterans that I've worked with do get an increase. You know, a lot of them come in unrealistically, they want 100%, and we can't get every veteran to 100%, but a lot of them do have errors. Does anyone have any questions on anything we put out tonight? Okay, then I'm going to touch a little bit on USERRA for about 5 minutes, since I have about 5 minutes left. USERRA is basically an employment statute that says that you cannot deny a benefit of employment to veterans. And our firm, this is one of the things that we specialize in, is USERRA litigation. We take cases nationwide, and our firm probably files more USERRA cases than any firm in the country. I was a former Army JAG officer. My partner, Matt Tully, is actually deployed as we speak to Afghanistan right now. He's a lieutenant colonel in the National Guard. What we're seeing is a lot of veterans, when they come back, National Guard, Reserve, and this applies to active duty, come back and their jobs aren't there. Either they're told, well, you know, while you were gone, we filled your position, or while we were gone, guess what? We cut your position. Well, USERRA is a federal law that protects veterans against that. And it protects not only against loss of their job, but anything that's considered a denial of a benefit of employment. What happens is when veterans deploy, there's an escalator principle. And what happens is as the veteran deploys, he steps on the escalator and he steps off where his peer would step off. Now, so that means if the peer who stayed back got a raise and the veteran comes back 3 years later, that veteran gets the raises. If that peer was to get the promotion, or the veteran would have got a promotion by staying, that veteran gets the promotion. However, the escalator can also go down. What do I mean by that? Corporation says, hey, we're having a terrible time in this economy. We laid off 100 people. If the firm can show that one of the people that would have been laid off was the veteran, the escalator can go down and the veteran comes back and may not have job protection. Where we also see USERRA denials is in initial employment, where employers will see on their resume National Guard or Reserve, and will deny them initial employment based on membership in the Guard or Reserve. USERRA even protects people that are not in the military. You might have an employee that comes in and says, hey, I need off an hour on Tuesday because I'm going down to the MEP station to join the Army. You have to give that person the time off, and you can't discriminate against them and say, well, you're joining the Guard, you're out. And we see a lot of blatant violations, and the violations are not just by local small companies, they're by the federal government, which is actually the biggest violator of USERRA, which is kind of amazing, and also by big corporations, Walmart, Target, you name it. We have cases against them all.
What many thresholds are there regarding the applicability of USERRA?
There are none.
Size?
No size. It applies to everyone. The only people it doesn't apply to are religious institutions. Catholic Church, it doesn't apply to them. And some of the alphabets, FBI, CIA, and I think the transportation, right? TSA. TSA it doesn't apply to because of national security. But other than that, there's no thresholds on it. Applies to everyone. USERRA is a federal law. New York State has its own protection as well under the New York State Naval and Militia Law. So if you're looking at one of these cases, you also want to look to New York State law because New York State, some of New York State's protections are actually greater than the federal government. You don't have to pay someone while they deploy. Some firms make up the difference, but there's nothing that says you have to do that. There's nothing that says that you have to continue them. You do have to continue them on medical, but you don't have to pay for it. The person that deploys does have to pay for it. Pension contributions, they'll have to continue, as if the veteran never left. And that's really what USERRA protects against. Protects and states that the veteran is to be deemed as if they've never left. And they come back, they basically come back into the job as if they had never left, meaning promotions, and that's where we see a lot of the fighting and a lot of the lawsuits are with promotions, pay issues, and just general, your job is gone, or now you're on the night shift and you used to work the day shift. USERRA cases sometimes are difficult to prosecute because it's not always easy to prove it. However, there are certain presumptions, such as when a veteran deploys and they come back, you can't fire them within the first, is it 60 days or 90 days?
You can't fire them for the first 180 days
If they've been gone, right. So if a veteran comes back, you can't even fire them unless it's for cause. But you can't fire them because it does protect them from termination. There's also protections in USERRA that when a service member comes back, they're entitled to take a certain number of days off before they even have to report back to work. We see this a lot of times with performance evals, that all of a sudden you had a stellar employee, she gives her notice and says, hey, I'm deploying, and all of a sudden the performance dives. So a lot of times we can prove that. A lot of times we look into the performance evaluations that will say, but for your absence during military drills, your performance was great. So sometimes there's smoking guns in there that people don't even realize are in their employment files. USERRA has a 5-year limit on it, which means that you can't go over 5 years with each employer. So you cannot have what we call a dual employment or dual careers. So there are many exceptions or exemptions to USERRA, which says that if you deploy for a contingency operation, an emergency operation, that is taken out of the 5-year statutory limit. So USERRA, if you do take USERRA cases do provide for attorney fees. However, it is in the discretion of the judge. USERRA provides for liquidated damages if you can prove that it was willful, the violation. USERRA also has equitable relief available to it. If anyone has any questions on USERRA, I'll stick around afterwards because we are seeing tons of USERRA-related cases, and it's only going to continue as the service members start coming back from Afghanistan. We saw the surge when they came back from Iraq, but now that they're starting to come back from Afghanistan, we're seeing it. And also just the employment rates or unemployment rates of veterans, we can see some of the discrimination. So it's illegal to deny any veteran a benefit of employment. So thank you for coming. And if you have any questions, I will stick around, and enjoy the rest of your night.